All right, if everybody could have a seat and please turn off your cell phones or put them on silent. I'm Don Donaldson, County Administrator. Welcome to our discussion on conflict assessment phase. I think the first order of business, I have a draft agenda in front of you. I think part of that agenda to basically agree on the process. This statute is open to the public, as is evidence here, but does not require public comment, or so the first order of the business would be is if Chair Hurd and the city would like to entertain public comment at some point in time. My suggestion is we would be at the end of the meeting and would follow our normal 3-minute rule for public comment. This process is really about the city and the county resolving a interlocal agreement where the county believes there are issues within that agreement that the parties need to resolve. And the result of that can be an amendment to that interlocal to resolve our differences is the goal here. To, at least from the county's perspective. So before we get started, if we could talk about the agenda and whether or not public comment will be considered in this meeting.
I'm okay with public comment as long as it's at the end of the meeting.
Absolutely. My only ask would be that, if possible, we have carved out here time for the administrators to speak, but not necessarily our attorneys. So.
Certainly. So if you look at the agenda, there's opening remarks to try to set forth. We can include another after discussion, additional. I think the attempt here is to really have an informal process at some, and so I leave it up to you all to. We can take breaks if you want and have the managers talk to one another, or the basic premise of today is to really to go over our differences, and there's certainly a possibility that we could come to a resolution on how we would move forward to take something to our boards. The conclusion may also be that we want to continue negotiations.
So for clarification, the format would be more of an informal discussion where we can all communicate versus set remarks.
Yes.
Perfect. That sounds great.
Okay, with that, I think agreement, then we will move forward with, I think, the informal stage of this. We've approved the agenda. I don't think votes and that sort of thing are necessary. It's really a conversation. Mm-hmm. So just in terms of the county's perspective, I have a timeline in front of you, and that was just to be illustrative of sort of the conversations that we've had since really the county on Brightline going back to 2018. And when the Brightline started service, and of course the city and the county at one time were working together on concerns over Brightline, but the county actually sued the Brightline over the various elements of it. We did ultimately enter in a settlement agreement that allowed us to resolve our differences. And then following that, Brightline, in that agreement that they would provide service in either Martin or St. Lucie. It was described as the Treasure Coast, but really that was what it was restricted to, as Indian River had backed out prior to the settlement agreement, did not settle with us. So they issued an RFP, and at that time the city and the county worked together on the RFP to invite Brightline to have station here in Martin County. We then certainly made each board approved the submittal. Ultimately, Brightline awarded Martin County. There was further amendments, and then fast forward further on, the city, of course, changed direction and decided not to follow through from our perspective. There has been some silence on negotiations. We attempted to negotiate, but ultimately the county on its own submitted an RFP so that we could be the project manager, if you will, for Brightline as we continue today. Ultimately, what brings us here today, though, is the commonality that we would support each other on the bringing a Brightline station here today. And while the subject of a letter to support our grant application has brought us here today, but really the reality is it's the interlocal agreement in its entirety, which included other elements such as construction of parking on Stitman, parking garage, support, those types of elements. So giving that in its totality, that is really what we're here to talk about, is our interlocal agreement between each other, which had these various commitments. And so Martin County is here invoking this process to essentially force a conversation, but our goal really is to see if we can resolve our differences, and we are open to discussing all those elements, including what support and participation means. Then the result of that would be an amended interlocal agreement that we could move forward with. And so that is essentially why we're here, and I have our counselor here and our chair is here to be open to that. Our expectation is that today is really a framework of discussion. While it would be nice to solve it all today, that's not our expectation.
It should be.
It should be, but I think we're hopeful that we can get to the heart of it, and if necessary, continue discussions. On the other hand, if we are unable to do that, we will discuss that at the end of what that means. So to keep it positive, let's try to move forward and talk about how we can continue to work together. Trains and train stations have been a part of our communication for a long time, and even back after the stimulus funds, there was an attempt to put a transit depot at the same property, and with the county and the city working with our federal partners back then. So it has been a long discussion from our perspective, and I think it's worthy of resolving our differences. So that's my introductory remarks. If the manager has anything you'd like to
Just
contribute?
briefly, you mentioned that you felt that there'd been some silence on behalf of the city. Just as a follow-up, we do agree with basically the timeline that in December of '23, we entered into a interlocal agreement to submit a joint response to the RFP with Brightline. And in March of '24, Brightline sent a letter to the city and the county responding to the interlocal agreement, or to the RFP, but changing some of the submitted conditions. And from March of '24 until roughly August of '24, the city negotiated with Brightline as well as the county to try to enter into a long-term lease agreement and terms related to the submitted RFP. But ultimately, when it was brought back to the city commission, the city commission had voted in August or early September that the counter offer from Brightline on March 5th that removed their obligation to pay 50% of the station cost was a material change to the RFP that the commission had not voted for. And as a result, the city commission chose to conditionalize the moving forward on Brightline contributing 50% of the station, and that's where the dispute basically arose. And that brings us here today. So we have the interlocal agreement, and we completely agree with you that it serves both the county and the city to amend that interlocal agreement to have it reflect what both entities believe is the best interest of moving forward and what obligations are there, so we both understand exactly where we're going.
And what are your obligations?
Well, I would defer to the city attorney on the legal side of it, but technically speaking, when Brightline made the counteroffer, the interlocal agreement said that in the event that Brightline accepted the proposal, then we had a series of conditions that we would have to follow. But that as of right now, Brightline has never accepted the request for proposal submitted by Martin County and City of Stuart. What they did is sent a counteroffer and made other conditions that the City of Stuart didn't agree to. So we could technically say that the interlocal agreement hasn't been triggered yet because it was never accepted by Brightline, those terms. But that leaves us kind of in an ambiguity because somebody might say, yes, it has, or I don't know, it hasn't. And I don't want to go down that path. I'd much rather come to an agreement and say, no, this is where we're at. And for example, if Martin County is going to go on with an RFP and the interlocal agreement says that Martin County is going to transfer the land to the City of Stuart, well, that's silly. There'd be no reason for Martin County to transfer the land to the City of Stuart, so we need to take that sentence out. And there'd be no reason, and the city would have no expectation that that would happen. And so, you know, I'm just as motivated as you are to correct those changes in it, and we can go with line by line if you want, or whatever. I also know that there was a clause that the city was going to maintain some parking around the courthouse. The city was planning to do that regardless of the interlocal agreement, and so we would continue to do that. And so there's some nuance there that I think we can fairly easily correct or whatever it might be. The question really becomes, you know, what is the direction? And I think it's between the elected officials to address the issues of, is there any relationship between the two of us moving forward, or what that is?
Well, I'm convinced that there is a relationship that we need to continue to pursue. But I need to understand what the city feels your obligations are under the interlocal, and what you plan to do in order to continue this partnership. What, if anything, you intend to do in order to continue this partnership.
And I would have to
We're
defer to the board.
partners.
Right.
So what are your intentions?
We are and we aren't. I mean, we've entered into a different realm now where the county is unilaterally going outside of that agreement. It's to some extent unfulfillable by both parties as it stands. So unless, you know, if you look in section 6, if you have that in front of you,
I got
right?
it right in front of me.
As to the train station, the cost of which is to be shared equally by the county and Brightline. That's, as you guys have created a new agreement with Brightline, that's unfulfillable. At this point, the agreement that you've amended with Brightline has Brightline paying $0 towards the station. So it is technically impossible for either party to fulfill the rest of that ILA. So and it's difficult being one of 5, but my viewpoint of how the rest of our commission feels as a whole, as a majority, is unless we're going to restore that part of the ILA, then with both parties unable to fulfill those future obligations, we should look to amend the ILA to relieve both parties of any unfulfilled obligations as of yet. Any future obligations, anything that's not been fulfilled so far should be relieved for both parties. To point to one party and say that those obligations need to be fulfilled, yet the other party cannot, it's, neither one of us, you know, again, can fulfill our obligations as stated in that ILA.
Okay, the city agrees to pay for the construction costs of the parking garage as necessary to meet the criteria set forth. Is that a statement that you agree with?
Are you going to transfer that land to the city? Again, we can go piece by piece and go through
Okay.
this. Are you going to have Brightline pay half of that station cost in section 6?
May I
Sure.
just offer a different perspective? This isn't an argument, it's to explain the county's position. I was involved in the 2018 settlement agreement and also in drafting of the interlocal agreement that we're talking about today.
Absolutely.
It's really important to read the whole interlocal. And one of the provisions in the whereas clause, which I would argue is very important, we talk about it's the second whereas clause in the interlocal, talks about the settlement agreement between the county and the Brightline. Best sentence, city was not a party to the settlement agreement. You will find that statement throughout the amended interlocal, which you all terminated, and also, my position was, and continues to be, the city wasn't part of the litigation, the city wasn't part of the settlement agreement.
Unfortunately, you included it in this agreement, so it is a part of it.
It was included in the agreement because the settlement agreement is what brought us to this point.
If that was your position, it should have not been included in this agreement, would be the perspective
Sure,
from over
sure.
here.
And again, I'm not
Because-
arguing with you.
And I'm not trying to argue, just
Yeah.
discussion, healthy discussion. This is
What-
the type of, that type of a deal is what the city signed on to in agreement with the county.
But the
So to
sentence
fundamentally change the nature of that deal, it's no longer, this ILA is no longer applicable.
So the statement that the city was not a party to the settlement agreement, as one of the authors, was in there to make it very clear that the station and the settlement agreement had nothing to do with the city. The city's not a party. When you continue to read the section you were talking about, again, it's qualified by saying, pursuant to the aforementioned settlement agreement with Brightline, county agrees to the 50% of the construction cost. Our agreement, not the city's, us. So I believe, since the city had no obligation under the settlement agreement, wasn't a part of the settlement agreement, our obligation that's recited in this interlocal, it all goes back to ours. It didn't affect the city in any way, and in fact, there's a section in at the end of the agreement that talks about if any term or provision, is invalid or unenforceable or changes, it doesn't make the whole agreement fall. But I'm not making, this is our opinion.
If you'll
I'm not
allow-
saying you have to.
There's a few things there if you'll allow us to
I
respond.
could just finish, and then you
Absolutely.
certainly
Fair enough.
can go. Throughout the RFP that was submitted jointly under the signatures of both the mayor and the chairman at the time, contemplate a negotiation. From the county's perspective, the interlocal was an attempt to show to Brightline our joint cooperation and getting along with each other. I do not believe, and if you look at the documents which were submitted to Brightline, the term negotiation is all along. I don't believe there was ever an expectation that there would be a complete offer of this. There was also always the word negotiation all the way through, which is the way most things happen in government, of a back and forth. So I think the county's position is the Brightline agreement was ours and ours alone. We are the only ones with Brightline that could amend it so that it wasn't a city issue. It was recited in the interlocal because that's how we came to the RFP. That's our interpretation of the interlocal. It is an element of what brought you to the table, but it didn't have anything to do with the city because it was our legal settlement agreement.
Did you?
Sure. In looking back at the settlement agreement when we were trying to draft the ILA, myself and the city manager were pretty adamant about trying to exclude the settlement agreement because this was a new deal. When Brightline put out an RFP, the settlement was done with. This is a new deal that they proposed. When you look at the interlocal agreement, it has two parts, an A and a B. A has to happen before B. And then the very first line of B has to happen before about 6 obligations are then active or triggered. So the first one was that the county and city agreed to submit the joint response to Brightline's request for proposal, and we agreed to do that on or before December 22nd, 2023. The county and the city did. And I think I have just a page of the financial terms in the RFP, and it injected that Brightline would be paying 50% of the train station, the county would be paying 50% of the train station, and the city would be paying for 100% of the parking garage. And that injected the terms of the settlement agreement almost again, but now including the city in our proposal. Our proposal was an offer, and the next Part B in our interlocal agreement, if Brightline selects the proposal. And as Mr. Mortel said earlier, Brightline never accepted our proposal as it was stated. They came back with a counteroffer. Legally, a counteroffer rejects the initial offer. And then now there's an offer for the county and city to accept. Now we're on the other end. And, well, the county did accept unilaterally in March Brightline's change in the terms. The city never did. So the city commission never voted or approved the change. And one of the changes that Brightline had in their,
March 24th.
no, that's the county's.
May I answer that? That isn't correct, Mr. Baggett.
Let me
Because
finish.
the board took no action. You're referring to a letter from our county administrator who, under Florida law, doesn't have the authority to bind the county. There was never a board vote.
All right, then neither board accepted the
position?
counteroffer of Brightline. Really? So I want to point out that Brightline, in its response, wanted not only to relieve its obligation to pay for anything of the train station, Brightline also asked for the city to pay the other half of the station, which it never had, and the parking, whether it was going to be surface parking or a parking lot. That was a significant change in the terms of the ILA. Nowhere in the ILA did the city ever agree to pay for the train station. And in their conditional selection, Brightline, on March 4th, again, they wanted to remove their obligation to pay anything towards the train station. And they passed that on to the city. The city clearly did not have an intent of paying for half the station and the parking garage, clearly as defined in the interlocal agreement. So unless there was an amendment, a modification to the terms that the city and the county agreed to, this interlocal agreement is not, we don't have an obligation to it. That was the whole reason why we drafted an amended interlocal agreement, which was brought to the city commission in August and subsequently rescinded before the county agreed to it. That was the whole purpose. We needed to amend the terms of the original interlocal agreement because those terms weren't agreed to tentatively between the parties. Likewise, what we're doing now is we are asking in the end of this that we amend the interlocal agreement so that moving forward, the parties have an idea of what their obligations are or not obligations under the agreement. As has been stated, the county has gone ahead and moved forward with its own agreement with Brightline. So obviously, conveying the parcel of land to the city shouldn't be an obligation on the county anymore. The city obviously shouldn't be negotiating and entering into a long-term lease agreement with Brightline. That's an obligation of the city. And also waiver of the 50% cost of the parking of the train station by Brightline. And obviously, the city should not be required to pay construction costs of the parking garage, or if it is surface parking. I know the interlocal agreement says parking garage, but at some point in time, that also was mentioned that Brightline could do enough spaces without constructing an actual structure, because that parking lot does have a lot of spaces there currently. Again, our hopes at the end of this is to amend the interlocal agreement so that everybody knows what the obligations are going forward.
We agree with that last statement. I think, in terms of the parking garage, those are things we're certainly want to discuss. We're willing to live with surface parking, those types of things. So I think there is room to make agreements on this. But I think the most critical elements are the surface parking related to Stitman and others that were talked about, the parking garage and what's disposed of that, and then what is meant by cooperation. It's as simple as support, or certainly, in our mind, while we would the support it would be beneficial, certainly. The opposite is also a concern of us, and that would be the city taking actions to harm the county's pursuit of a station. And so that's really partly why we're here too, is the perception that the city is outwardly trying to undermine the county's attempt to
Would you give an
build a
example
station.
of
So I
that
think
specifically?
that's our concern.
Do you have a specific example of that? Of
I
what
think the continued change in the city's actions to move the target and claim the county is a train station is not a benefit to the public. So I think that's those comments are
What are you
a concern to
referencing?
us.
What comments are you referencing in saying that?
So let's continue to discuss the agreement.
So I would, to discuss with you, I would say, since the election, the city has been very consistent, and in fact, consistent with what the county's position was before more recently. And I would say consistent with the average resident and taxpayer that does not feel like Brightline should be completely off the hook for the train station, and the taxpayer should pay 100% of it, or at least, in your comments in the past, the lion's share, to echo your very pointed and accurate comments. The county is who moved into a new direction and moved the target. The county is who let Brightline off the hook for paying anything, not the city. The city is not actively fighting you. I can't speak again for all five of us. I can't poll votes without having it come to the dais, Don, but the city, I am sure, would support a deal like they had in the past, where Brightline paid for half. But the city does not support and cannot support with a letter for your grant application, a deal where Brightline pays $0 in this public-private partnership.
That's good to know. That's an important piece of the agreement as written, that you would support grant applications and
With a deal where Brightline was paying for half, which residents supported, taxpayers supported. But this current deal that you've entered into, you've gone rogue and entered into on your own, outside of this ILA, the city cannot support.
the county has preserved its interest in getting a train station here, and that's what they've done.
I would, from the standpoint of from a technical standpoint, the county's agreement with Brightline, does discuss funding, but it depends on how you define taxpayer dollars. So the Board of County Commissioners, from the moment of of the first ILA until the current agreement with Brightline, has capped the total exposure to the taxpayers of Martin County, to Martin County, not taxpayers so much, to
Correct.
Martin County.
Correct.
To Martin County at $15 million. The rest of the construction of the station, under the terms of the Brightline amended agreement, talks about getting federal and state monies, which from a factual standpoint have already been appropriated by the federal government, are in the process of accepting applications. So from the standpoint, if we're talking about it from the standpoint of the pocketbooks of Martin County. The citizens of Martin County nor the city of Stuart are going to get a rebate on their federal income tax, whether the money is paid for out of these federal grants. Those grants have been appropriated. If they don't go to Martin County, they'll go somewhere else.
But grants are not fund coupons, right? They're taxpayer dollars.
They were paid through.
Federal taxpayer dollars.
They're federal
Correct.
taxpayer dollars, I agree, but they will go somewhere. They have been appropriated.
Taxpayers are funding 100% of the cost of the station in your
Which-
current deal.
Which in looking at, and I just want to point out, in looking at the history of rail in the United States of America, have been solidly supported through federal rail, the Federal Rail Administration. You can look at any kind of a rail system in the United States, and it is solidly, in the history of the United States, have been in part funded through federal appropriations.
In
So,
part, correct? In part.
well,
Wholly?
I don't pretend to know anything about rail, so
Or in
I
whole,
won't
I mean.
debate that with you. But I would hope to redirect, we could get back to which parts of of the original interlocal could we agree upon? Could we agree upon, as we said, getting rid of the parking garage? I don't think the county has any problem with that, correct, Commissioner or
I agree.
County Administrator? That's something we would agree with you on.
Neither one of us can fulfill our obligations in this ILA, correct? Neither one of us can fulfill.
Why do you think we can't?
Are you going to transfer the land? Are you going to have Brightline pay half? I mean, it's not happening, correct? So if that is the reality of this, not picking this apart, why would we not just relieve both parties from future obligations yet fulfilled? I don't know why we would want to go piece by piece and try to, for something that can't be enforced for both sides.
If you're asking to eliminate provisions that are no longer relevant, we agree with that.
Neither party can fulfill the obligations. So we should be going back to our respective commissions and crafting the amended interlocal agreement that has both parties relieved of future obligations yet fulfilled. Part of this has been, already effective, but what has yet to be fulfilled should be relieved for both parties, so we can both walk away and the taxpayer can save money.
There is also an additional constraint, I would say, or a law for the city of Stuart, which involves your comprehensive plan, which says shall, talks about a station precisely in this location, precisely the actual. And so the question perhaps the county may have is, set aside the interlocal agreement, what about the requirements of your comprehensive plan, which says shall, is a planning document that's, as my understanding, has been in place a long time. Is there a way to square that with the county's desire for, and again, Mr. Donaldson and I think Commissioner Chair Hurd have mentioned, of what exactly would support or at least not opposition to look like?
Again, the characterization of opposition. Again, the city's very much in favor of supporting a station under the terms of the ILA. That was the original deal. The city is not opposing or against a train station. Just for clarification, that's been raised up by both of you two. Do you mind speaking to that, Lee?
No, I would say that the policy and objective that you're referring to in the comp plan is not an absolute. For instance, if you're requiring the city to pay you $1 trillion to build a train station, that would be, not required under the comp plan. And I'm just using $1 trillion as an exaggeration, but in the city's mind, it is not a good decision to mandate that the taxpayers pay up to $50 million for a train station potentially without Brightline paying for it. And again, as he's described, we're not against it. We're fine with the terms of the original interlocal agreement, which has Brightline paying for half the station, and the city paying for the parking and the county paying for half the station. So we are not against it. It's just the amount of money that is required of the city and not Brightline. What you're seeking is for the transfer of the obligation of Brightline to move over to the city, which the city has not accepted.
In the amended ILA, but,
We're not asking for this.
We're not asking for the city to put in a nickel.
correct. He's, I think, referring to the amended
So
ILA.
explain to me how, under the money that the city has jurisdiction over, what part of the city taxpayer money? I understand the philosophical objection to the federal funding, but that's a matter of the Martin County Commission under their jurisdiction.
I don't know that we can say with an absolute certainty that the federal grant or state grant would be there. There has been a change in climate in the administration, obviously with the president and executive branch. Who knows what could happen tomorrow as far as them changing grants. As far as the city was on the hook for providing a parking garage at the most to this train station. And possibly only surface level parking, which would not be $30 million. That is Brightline in their counteroffer, which the city has not accepted, puts the city on the hook for $30 million because it's the train station and a parking garage. So the city is not in agreement on that. I don't think by rejecting that is violating the comp plan because we entered into an interlocal agreement with the
That's the point he's
anticipation
making.
of going
Rejecting-
forward with it.
I
Rejecting
understand
Bright
that,
Line's
but
deal is
Mr.
not-
Baggett, as you well know, the city, which was within the right, the city terminated both the lease agreement and the amended interlocal with the county.
We
If
rescinded,
that
we
were
didn't
rescinded.
terminate.
I'm sorry.
Before it was executed, while we were still in a
did.
period of due diligence, hold on, while we were still in a period of due diligence, we rescinded it. We did not terminate it.
I don't disagree.
Thank you.
Now we are, the county, pursuant to our rights, we have an agreement with Brightline, a valid agreement. City's not in it.
Correct. We are not a party to your
You
agreement.
have read our agreement.
Why are you coming to us?
Because the interlocal agreement still remains in effect.
How can it when you've
I could just-
departed from all of the terms of it?
Just want to make sure that factually we are both on the same page. The settlement agreement with Brightline provides for a maximum of $15 million of county money. And then it has an agreement that will have, I think it's about 2 years, to apply for federal and state funding to make up all of the rest of the cost of the station and the infrastructure that's required for that. That's between the county and Brightline. That's it. And it has a maximum exposure of however the county determines in their discretion how they're going to pay for it. Mr. Baggett's comments about Brightline's counterproposal, dead. We moved on. That is not bind you in any way, and I will be happy to agree that you aren't, we've already said it, I think, twice. We don't want to do are not asking you to build a parking garage. We're happy to concede. So if there's no monetary obligation to the city, I don't understand why we keep talking back to that March counterproposal. That's gone. We have entered into a valid agreement with Brightline. All those other documents are in the past, but we still have our interlocal agreement. You all did not rescind it. My question is there a way for us to amend this interlocal agreement? I believe there is.
Yes.
We need to work together, and that's where Commissioner Hurd and Mr. Donaldson come in to how do we amend that? If you're concerned about city money going to the Brightline station,
At this point, no.
that's something we can easily resolve.
The primary concern is the nature of the deal. So to your point, the philosophical objection.
The nature of the county's deal with Brightline?
Because it departs from the interlocal agreement, the type of deal that the county was in with Brightline when this deal was crafted, when this interlocal agreement was crafted, had Brightline paying half. This is a big deal. Again, to the city manager's point, this is a material change in that agreement. city signed on and joined with you in that kind of an arrangement. In March of '24, when you agreed to Brightline's terms to let them off the hook for paying anything, that fundamentally changed this entire arrangement. So now to try to pick and choose pieces of this ILA that you want to hold the city accountable for, if you did not want that settlement agreement to be a part of this ILA, you should have left it out, but you didn't. And in fact, it's buried in Section 6, the very section you're trying to hold us accountable for, is that as to the cost of the station, it would be shared by the county and Brightline. As a representative of taxpayers that also pay federal taxes, grants come from taxes. It's not just that we're limiting exposure of county residents to 15 million, that's great, but you're also having taxpayers fund the entire station cost. And I know I'm beating this to death, but this is the most important part of this.
Well, perhaps I can,
The city cannot support that kind of an arrangement.
if I could ask a question then, if our agreement with Brightline is not going to change, and if that's not going to change, are you able to amend the agreement with us?
So again, to my other point, if that's not possible, if we're unwilling or unable to do that, then the next logical step is to relieve both parties of yet fulfilled future obligations that are in the ILA so we can both go our separate ways and not be trying to nitpick through this agreement who should be doing what, because it is not fulfillable by both parties. I think that is the most logical step here, so we're not quibbling over details.
Then I would suggest that there's really no need for further discussion with you regarding the changes to the interlocal. We have our position legally regarding it. I would say that our next step, if we want to, if the county feels a continuation on it, it would be to impasse and take the next step in the intergovernmental process. Because we're not looking to change our current deal with Brightline. It's going to stay as it is.
You're not willing or able to amend the ILA to relieve both parties of future
So the next
obligations?
discussion would be if our task is to, at this point, we're looking to amend the existing interlocal agreement to satisfy principally those three areas I talked about. What does cooperation mean? What do we do with the parking garage, which you know our position, and the continuation of the city to provide the parking on Stitman, which it sounds like you plan to do anyway. So that's really the fundamental, I think, three pieces of it that are warranted to make those changes. You've, I believe, made it clear that
again, to
those changes can only be made or considered if the county amends its agreement with Brightline in its current structure. So I think that's, there's really no reason to go through anything else if that's the sticking point.
Okay, we done?
Then I think I can stay here and take public comment if you want, or how you want to handle it. So, Counselor, do you have anything? City Manager? Okay, so then we will have, do we have a microphone for public comment?
Okay. Pop folks right here. And we do have forms at the back. We would ask if anybody does public comment, if they could come fill one out after the fact is fine.
So if you could state your name for the record when you come to the mic,
And you'll have 3 minutes.
and you'll have 3 minutes.
Thank you for having this meeting. Thank you for the people that have come. Thank you for giving me an opportunity to speak. How can we go into an agreement with not having the business that's coming into our community and not ask them for any money? Question number one, which is really not part of this, I guess, since Martin County is going to do this on its own. How can we not want to do a joint venture with the city of Stuart in partnership because of the traffic that's going to come in, because of the road that's going to have to be repaired, because of the whole, we're talking about something that's going to affect both parties in this. So I don't understand how and why we would want to eliminate Stuart from the plan. And then number two, the contingency plan. Is there one if we don't have any grants? What if we don't get the grants? Will Martin County be bound to the total amount of the cost of this construction project? And number four, what about public transportation for people like me that needs the help of the county? How is that going to affect our end of this? Will you have to eliminate that to pay for the train station? Thank you.
Oh, go ahead. We're just going to scoot this over a little bit. Sir? Nope. It's you.
Again, I'd like to say thank you for having this meeting and allowing us to be here. My name's Tom Lloyd, and I'd like to point out that the county meeting was held in a rush before the new commissioners were able to come on and have a say. In that meeting, I think there's video record, public record, that says or displays that Commissioner Smith, I think it was, moved that the county move without Stuart. Keep going forward without Stuart. I don't understand what we're doing here today. If you guys made the decision to go forward without Stuart, why are we fighting against Stuart to force them to be a part of it? I don't get it. The other thing is, as a taxpayer in the county, I don't agree at all with paying for a private business, and I believe our county documentation says that we aren't supposed to be spending our dollars to fund a private company. So I'm hoping that you all will stick to the documents as you should. I'm hoping you will guard the taxpayers' dollars against funding private companies. Thank you.
Good afternoon, Robin Cartwright. Thank you for hosting this meeting today, and I look forward to tomorrow's meeting as well. I just want to point out a couple pieces of fact that seem to be neglected during this conversation today. The station, for those who don't know, is currently being proposed to be on a street that's currently rated D by the Florida Department of Transportation. There's been no accountability or any discussion about how to improve the traffic situation surrounding that road. On 12/11, at the city meeting of 2023, the county administrator said the county didn't know how big the parking garage would be or how much it would cost. And yet on December 12th, the very next day, the county administrator said in his presentation the garage would be 200 spaces and cost the city of Stuart $30 million. No voting was funded on in that previous meeting by the city of Stuart. So nobody knows where those numbers came from. The ILA didn't mention it, and yet it was part of Brightline's counteroffer in March in that letter. The city had no say. Brightline removed themselves from any obligation, and additionally, the MPO that the county is supposed to abide by says that all rail will be privately funded. Regarding the comp plan, it does not say that taxpayers are responsible for the cost of a train station. It only says that they shall encourage and try to get one. So does Brightline ever contribute? On August 27th, 2024, there are documented text messages between a city commissioner and a blogger that states, and I quote, "Without a FOIA request, Boca received 16.6 grant, I assume that's $1 million. Brightline kicked in 30, and Boca had to pay 9.9, half of that they got from other grants. So Brightline does contribute."
Frank McChrystal, City of Stuart, Martin County. The fairgrounds would be great. I mean, what's wrong with the fairgrounds? That's number one. And The commission, the Stuart City Commission, that allowed this 12th hour change that shifted the costs from Brightline and the county to the backs of the city of Stuart, were overwhelmingly rejected in the very next election. So there's your sign. Thank you.
Good afternoon, Commissioners. I want to let you know that I certainly do appreciate all the work that each and every one of you do. I know your hearts are on the county and all of the residents, whether they're city residents or county residents, so I thank you for that. And I just wanted to say that I take offense to what Mr. Donaldson said about the city trying to undermine the county. I have been to numerous meetings, the city commissioners. And I can tell you that they have not disparaged the county in any way. And when Mr. Donaldson was put on the spot by Commissioner Collins to give an example, he completely ignored that and did not give an example. So I just want to let you know that the history of the funding of the trains, as Attorney Wood said, I think you need to go back and check your history, because these trains are funded by themselves with city and federal and county monies that come from grants, and grants are not always available. Who knows what's going to be available by the time that you want to go back and re-look at this, take another look at this. So applying for more grants in 2 years, I would say that we're really putting ourselves in a lot of jeopardy on that, because there very well could be no money now currently available or in the future. Thank you.
Can I get your name, ma'am? Can I get your name?
Okay, that concludes our meeting. Thank you.